So, we'll discuss question number 14. Define natural justice and explain the principles of natural justice involved in administrative law. And question number 15. No person shall be a judge in his own case. Comment. And question number 16. Explain the rule of Odi alterum partem with illustrative cases. And question number 17. Explain the term reasonable opportunity and cite some important cases decided by the Supreme Court in its support. So, regarding natural justice, the very meaning of natural justice as it was announced in the Supreme Court decision in 1994 in the leading case Ravi S. Naik versus Union of India, that principles of natural justice have an important place in modern administrative law. They have been defined to mean fair play in action and order of an authority exercising judicial or quasi-judicial function passed in violation of the principle of natural justice is procedurally ultra-virus and therefore suffers from a jurisdictional error. So the rule of natural justice are foundational and fundamental concepts, and law is now well settled that the principles of natural justice are part of the legal and judicial procedures. Principles of natural justice are applicable to almost the whole range of administrative powers. And in the leading case Maneka Gandhi versus Union of India in 1978, it was held by the Supreme Court that natural justice is an essential part of the philosophy of law. There is nothing rigid or mechanical about it. Any analysis must bring into relief rather than a spirit and then inspiration than any precision of definition or precision as to application. The principles of procedures are to be applied with any particular situation or set of circumstances are right and just and fair. So natural justice is a great humanizing principle intended to invest law with fairness and secure justice. So the very question of natural justice also was explained in the leading case Swadeshi Cotton Mills versus Union of India in 1981 as the very phrase natural justice is, although not capable of static and precise definition, it cannot be imprisoned in the straitjacket of a cast iron formula. It is not possible to make an exhaustive catalogue of such rules. Rules of natural justice like ultravirus and public policy is a branch of the public law and is a formidable weapon which can be wielded to secure justice to citizens. So, the very concept of natural justice as accordingly accepted for essential necessities such as notice, opportunity to be had an impartial tribunal orderly course of justice, and thus is in simple words. The rules of natural justice can be summarized as one cannot be a judge in his own case. One who had should decide opportunity to the parties of being had and producing evidence in support of their allegation, and also the right to cross examination. Thus, the principle of natural justice in terms of administrative law or a quasi judicial authority cannot make any decision adverse to any party without giving an effective opportunity of meeting any allegation against him. So also that every person whose civil right is affected must have a reasonable notice of the case he has to meet. So also that he must have a reasonable opportunity of being had in his defense. So also he must have the opportunity of adducing all relevant evidence on which he relies. The evidence of the opponent should be taken in his presence, and that he must have the opportunity of cross examination of the witnesses examined or relied upon by the opponent. The documents which are necessary for the purpose of an effective exercise of the foregoing rights should not be withheld from such person. So, also, the question number 15, as no person shall be judged in his own case, it is actually the rule against bias. So, bias means an operative prejudice, whether conscious or unconscious, in relation to a party or issue. Therefore, the rule against bias strikes against those factors which may improperly influence a judge in arriving at a decision in any particular case. So, the requirement of this principle is that the judge must be impartial and must decide the case objectively on the basis of the evidence on record. So, regarding bias, there are following varieties of bias, and such as personal bias. Personal bias arises from a certain relationship equation between the deciding authority and the parties which incline him unfavorably or otherwise on the side of one of the parties before him. Such equation may develop out of varied forms or personal or professional hostility or friendship. And also regarding pecuniary bias. So, the judicial approach is unanimous and decisive on the point that any financial interest, however shall it may be, would vitiate administrative action. The disqualification will not be avoided by non-participation of the biased member in the proceedings if he was present when the decision was released. So also the subject matter bias, and the cases which fall within this category are where the deciding officer is directly or otherwise involved in the very subject matter of the case. Have again mere involvement would not vitiate the administrative action unless there is a real likelihood of bias. And so also another kind of bias is the departmental bias. So departmental bias is something which is inherent in the administrative process, and if it is not effectively checked, it may negate the very concept of fairness in the administrative proceedings, and also the preconceived notion bias arising out of preconceived notions is a very delicate problem of administrative law. So these are the bias which will definitely cause impossibility of performance under the very rules of or principles of natural justice. And now we'll go to question number 16. Explain the rule of odi alterum partem with illustrative cases. So, the very question of odi alterum partem, exactly it means that the administrative agencies in India are not bound by the technical rules of procedure of law courts. They need to follow the minimum procedure of fair hearing. The courts from case to case have in their decisions developed a fine code of administrative procedure and which applies to every administrative decision. And there is the requirement of right to fair hearing is a code of procedure and hence covers every stage through which the administrative adjudication passes, starting from notice to final determination. So, right to notice, that is the starting point of any hearing, and it contains the following: the very time, place, and nature of hearing, the legal authority under which hearing is to be held, and the statement of specific charges which the person has to meet. So also it contains that right to present case and evidence. So in that case, the adjudicative authority should afford reasonable opportunity to the party to present his case. This can be done through writing or orally at the discretion of the authority unless the statute under which the authority is functioning directs otherwise. Then the right to refute or adverse evidence. So the very right to refute adverse evidence presupposes that the person has been informed about the evidence against him. For this, it is sufficient that the summary of the contents of the adverse material is made available, provided it is not misleading. So also, another one is cross-examination. Cross-examination is the most powerful weapon to elicit and establish truth. However, the courts do not insist on cross-examination in administrative adjudication unless the circumstances are such that in the absence of the person cannot put up an effective defense. So also it requires legal representation. So representation through a lawyer in any administrative proceedings normally is not considered as indispensable part of the rule of natural justice, as oral hearing is not included in the minima of fair hearing. The denial of legal representation is justified on the ground that lawyers tend to complicate matters, prolong the proceedings, and destroy the essential informality of the proceedings. However, the courts in India have held that in situations where the person is illiterate or the matter is complicated and technical, or expert evidence is on the record, or a question of law is involved, or the person is facing a trained prosecutor, some professional assistance must be given to the party to make his right to defend himself meaningful. So also, regarding the evidence should be taken not at the back of the other party. So, ex party evidence taken in the absence of the other party violates the very principle of fair hearing. So, also, lastly, report of the inquiry to be shown to the other party. It is the established rule of natural justice that the report of inquiry is to be shown to the other party, and the reasoned decision or the speaking order, as in India, in the absence of any particular statutory requirements, there is no general requirements for the administrative agencies to give reasons for their decisions. However, if the statute under which the agency is functioning requires reasoned decision, the courts consider it mandatory for the agency to give reasons which should not be merely rubber stamp reasons but a brief, clear statement providing the link between the material on which certain conclusions are based and the actual conclusion. So also the rule against dictation is applied. Any administrative authority invested with the power of decision making must exercise this power in exercise of its own judgment. The decision must be actually his who decides. Therefore, if a decision is taken at the direction of any outside agency, there is a violation of fair hearing, and decision reasoned best is the very requirement of the principle of natural justice. So now we'll go to question number 17 and explain the very term of reasonable opportunity and cite some important cases decided by the Supreme Court in its support. So, exactly reasonable opportunity has the following two elements. An opportunity to be had must be given, and the opportunity must be reasonable. So, the very decision of this question necessarily depends upon the peculiar facts and circumstances of each case, including the nature of the action proposed, the material on which the allegations are based, the attitude of the party against whom action is proposed in showing cause against such proposed action, the nature of the plea raised by him in reply, the request for further opportunity that may be met, his admission by conduct or otherwise of some or all the allegations, and all other matters which help the mind in coming to a fair conclusions on the question. Thus, the whole term reasonable opportunity to show cause is a phrase with variable context. It may include three things: an opportunity to deny the guilt and to prove by furnishing evidences one's innocence, and secondly, an opportunity to produce one's own evidence in support of one's case and to cross-examine the witnesses produced against each case, and thirdly, an opportunity to make representation stating reasons why action should not be taken against him, and The very refusal to furnish copy of inquiry officer's report to delinquent amounts to denial of reasonable opportunity as it was decided by the Supreme Court in 1994 in the leading case Managing Director ECIL versus B. Karunakaran. Also, in the event of registration license being proposed to be cancelled, an opportunity should be granted to such agency that would answer the requirement of natural justice and would uphold a healthy scheme of administration as it was decided by the Supreme Court in 1992 in the leading case Lakshmikant Pandey versus Union of India. So, the very question of reasonable opportunity, as with this observation held by various court of justice during the past years, we find a very healthy tendency developing in favor of the rule of natural justice in India. So, in our upcoming video, we will discuss the next remaining questions